Be seated. We're ready for argument in 23-365, EIS Development 2 versus Buena Vista Area Association.
The court, Mr. Caulfield will present argument for the petitioner. Petitioner has reserved 3 minutes for rebuttal.
Good morning. May it please the court. My name is Lance Caulfield. I represent EIS Development, and we appreciate your time this morning because this case involves important issues relating to restricted covenants, the interpretation of restricted covenants, when equity says those covenants should cease, and who should be a party to those decisions. Now, the first issue, the interpretation of restricted covenants, I believe to be dispositive. And so with the court's permission, I'll begin with that issue because it controls the others. But this is the court's time. We appreciate it. So if the court wants to address any other issue first, just let me know. Very well. Then going to the interpretation of these restrictive covenants. The trial court and the opinion found the following language to unambiguously be a density restriction. That language found in the CCRs is, no more than 2 residences may be built on any 5-acre tract. The injunction that was entered states as follows. On the property, no more than 2 main residences per 5-acre tract shall be built. Now, in order to comply with that injunction, with changing the word any to per or for each, there's really only one way to do so. And that is to see it as a 2.5-acre density restriction with just 1 residence per lot. But that's not what the restriction says, and it's not how it should have been interpreted. It was interpreted that way for really 2 main errors. The first...
Okay, where are you? I mean, it seems to me that that's really stretching the English language to say that those 2 things are not basically saying the same thing.
That any is not the same as per?
Well, those are 2 different words, but in this context, it seems to me that those 2 have the same meaning.
Well, the context is important, and the context, of course, is the failed supercolliding superconductor. There were over 12,000 acres that were condemned for the ring that encircles Waxahachie and for the labs that were on the east and west side of the ring.
And what does that have to do with any and per?
Any and per? Because it deals with land use and what is the meaning of these regulations. The regulations were, again, for something that completely encircled a city, and they contained 7,000 acres on the west campus, a little over 7,000 acres on the west campus. And so why would the use be 2 residences on any 5-acre tract as opposed to a minimum lot size of 2.5 acres? Most likely because of platting. That's why 5-acre tracts are usually referenced when it comes to city planning and to platting, is that 5-acre plats or less are platted by the city. Tracts of greater are not. And so these restrictions, by focusing on any 5-acre tract, a specific size of tract, not per 5 acres, most likely it's referencing platting, it's referencing development. And again, it's important that the CCRs also incorporated all the regulations and the codes of the surrounding municipalities in the county, knowing that this city would grow, knowing that regulations would be imposed as to platting, that they eventually would reach out. In fact, now this property is in the ETJ. The city limits are just a mile away. And that under this court's law, whenever there is a more restrictive zoning or ordinance in place, then it controls over the restrictive covenant. So any 5-acre tract covers 5-acre tracts. But as the city expands, as it applies its own platting, then the platting, which is more restrictive because it applies to something other than 5-acre tracts, must have been what was intended to then apply.
Was the property divided into 5-acre tracts at the time that restriction was?
It was not. It was not, Your Honor. The tracts were all of various sizes. The ring itself was about, I believe, 70 feet wide, and so very odd shapes for those. But the campuses were in tracts of, like I said, about 7,300 acres for the west tract. And so it is a bit of a mystery to try to figure out why 2 residences per 5 acres as opposed to 1 residence per 2.5, if that's really what it means.
This whole tract, this whole area of land, when they were getting ready for the super collider, was just the whole nature of it was changed because they thought they were going to build a super collider plant. And so everything was, bought up by eminent domain and, so whatever had been there was kind of gone. And so they're starting from scratch. So you could think of a lot of reasons to retain a rural character, to prevent against urban growth. There's lots of things that they could have had in mind.
And ultimately, that's what the lower court, that's what the trial court said the purpose was to preserve the rural character of the property. And that really strays into the second error that was made, and that was ignoring this court's common law rules of construction. We know that on opinion page 388, the opinion said that it does not decide whether, quote, the common law standards of strict construction have any place in our construction of restrictive covenants, because it found the CCRs to be unambiguous. Now, that statement is remarkable, given this court's language in Wilmoth. In Wilmoth, this court said that restrictive covenants are disfavored because they are distorting the nature of the property right, the value of the property. And so 2 main rulings came out. One was that the covenants should be interpreted in favor of the greatest use of the land, and the second, that restrictive covenants cannot be enlarged, stretched, or changed by construction. Now, when the opinion says it has no place for the common law rules, it's saying that in the context of a discussion of 202.003, which it seems to be applying. The court's familiar with that language. The language of 202.003 is, a restrictive covenant shall be liberally construed to give effect to its purpose and intent. The opinion in finding no place for the common law, but apparently relying on liberal construction to determine purpose and intent, was violating not just Wilmoth, but the actual language of the statute. The statute simply does not displace the common law. The statute does not say a restrictive covenant shall be liberally construed to determine its purpose and intent. The statute says that you give a liberal construction when you know the purpose and intent. Allowing courts to use 202.03a and anything other than the common law presumptions enables those courts to do what this court said they should not do in Wilmoth, and that is, again, quote, the words used in the restriction and the restriction as a whole may not be enlarged, extended, stretched, or changed by construction. That's what the court did when it changed any to per. It changed the language by construction. It said it was not relying on the common law. It indicated it was relying on 202.03a. It was liberally construing and creating a purpose and intent that was not found within the plain language of the CCRs.
If we agree with you that it's ambiguous, do you then think that we ought to have a jury find what the appropriate construction is, or just apply the presumption against restrictive covenants, which would seem to push it in the other direction?
Well, it would push it in the direction back to Wilmoth. Wilmoth was decided after the enactment of 202.003a. Wilmoth is the general rule, and Wilmoth should be what would be applied if this court found that it was ambiguous. But I think what the court probably should do is what it did in Tar, and that is to say that these restrictions do not unambiguously contain a density restriction. And so the injunction which imposes one should be reversed. Now,
just so I understand, was there any expectation in other law at the time of the original conveyance that contained the restrictions that the tract would not be smaller than 5 acres?
Your Honor, the only pronouncement in the law that's relevant to 5 acres that I was able to find deals with platting.
And if it was county platting versus city platting, as you alluded to earlier, is there something in the statutes or rules governing county platting that says it can't be smaller than 5 acres?
At the time, Your Honor, I believe, and this is in the brief, I believe it was 10 acres for county, 5 acres for city, which again would make sense that they would go with 5 acres. In fact, later on, the city and the county entered into an agreement that they would jointly do platting underneath their various standards.
But those rules have changed since to
Those
allow
rules have
platting of
changed since.
smaller. I see.
Yes, Your Honor. Yes, Your Honor. In fact,
If there were segments that had been divided into 5-acre tracts, would you concede that there can only be 2 residences on those?
that would be the only time, I believe, Your Honor, that it would be unambiguous, was when we were dealing with a 5-acre tract.
Well, so does the record tell us that there were no 5-acre tracts anywhere on the entire ring, or only that or what does the record tell us about the existence of any 5-acre tracts?
Unfortunately, Your Honor, the record doesn't tell us much about any other tracts. We know from the affidavit of Mr. Hess, which was on summary judgment, I believe that was at page 1686, that the general area surrounding this plat was about 40 to 50% covered by the restrictions, similar restrictions, but we don't know plat sizes. Very good. Well then, turning quickly to the affirmative defenses then, to waiver. As this court has said in Cowling, waiver or abandonment must show that violations of deed restrictions are so great that the average man would conclude the restrictions have been abandoned or waived. Now, waiver has been developed into a multi-factor test in cases like Hicks versus Lovelace and the BCH case that looks at a multitude of different circumstances, including the nature, number, and severity of violations, the prior acts of enforcement, what degree of benefit is still substantially existing to maintain the restriction in the first place. Now, the first problem with the summary judgment that was granted on waiver is waiver was only challenged as to an intentional relinquishment. In other words, a traditional waiver standard. That's understandable because the law, quite frankly, has been confusing on this issue. Cowling says waiver or abandonment. Some cases talk about abandonment. Some cases group them together. Some cases just talk about waiver.
When you're talking about waiver, are you talking about that the plat was approved and not objected to, that waiver, or are you talking about changed circumstances in nearby developments?
And that is part of the confusion in the law. The general rule is that waiver is looked at as to the changes that are within the restricted area. Changed conditions looks at changes in and surrounding the area.
Well,
And
didn't
so
they sue less than 3 months after the city approved the plan?
They did sue after the city approved the plan, but the record, in fact, their stipulations 25 through 32 show there was no objection to the platting, there was no appeal of the platting, there was no motion for reconsideration of the platting, and there was no mention of any density restriction at the one hearing that occurred by any of these defendants, even though they were present.
So what's your authority that they needed to do more than bring suit? They brought suit within 3 months.
They brought suit within 3 months, but at the very least, this raises a fact issue as to waiver. Because not only do we have their inaction, and again, the record shows that not only was this platted, Mr. Salvador moved his equipment out. He did grading, he did construction, he started to prepare the land. And even when the injunctions, the agreed injunctions were entered into, they allowed him to continue that work in conjunction with the platting. The platting was a change, and it was a change that occurred without any objection. At the very least, that should have raised a fact issue. This was on summary judgment again, a fact issue. Now, the law does say that whenever we examine waiver off-site, it's given less weight. The law also sometimes refers to waiver as just an intentional relinquishment of a known right. But I want to talk briefly about those cases, in particular about the Till Trading case that Your Honor authored. The Till Trading and the Sharpstown versus Pickett cases, the only theory of waiver that was brought up was traditional waiver theory. This theory, the multi-factor test in Cowling and BCH, was not. It is a different animal whenever we're referring to restrictive covenants. And so just restricting the summary judgment to one element of traditional waiver was improper, because this is a balancing test and a multi-factor test that usually is an issue of fact whenever it's properly raised, which it was on this summary judgment. Now, changing to changed conditions. One of the other primary areas of equitable disentanglement of restrictions is the changed conditions defense. And as we talked about, changed conditions deals with conditions that have changed since the inception, over time, that have made it, according to Cowling, no longer possible to secure in a substantial degree the benefits sought to be realized through the restriction. Now, the trial court imposed a temporal restriction on changed conditions. That restriction comes from, well, it's cited to Davis, but Davis took it from Lebo. That's why we call it the Lebo rule in our briefing. And Lebo took this rule from Avondale, which was a 1938 Florida decision. Lebo is the only case that drew from that decision and adopted it. And yet Texas has, over the years, inconsistently followed that rule. The Lebo rule that looks at no changed condition prior to purchase has been rejected in every other state that has looked at it other than Florida. In Florida, it was heavily criticized for years until it was finally reaffirmed in Wood versus Dozier. And the dissenting chief judge in that opinion said that there was no basis in logic, reason, or fairness for that rule other than the basis of stare decisis.
So this is a little hard for me to follow, because if the purpose of these persons who bought these tracts with these deed restrictions in them was that they wanted there to be no more than 2 homes on 5 acres because they want to have that rural feeling, they don't want to have the urban sprawl, they don't want all of that, they just want to live out in the country, which Waxahachie is, then what changed? Even though there may be a few developments here and there, my understanding is that it's still very rural out there.
Well, first, Your Honor, I don't want to correct you for sure because you've written most of the opinions on several of these issues, but it's not the intention of the purchaser and what they desire to acquire from those covenants. It's what the covenants were intended to do in the first place.
Well, it's both. I mean, obviously,
Right.
there's some some equitable notice issues involved when people buy land.
Correct.
And certainly you look at what those were meant to do. And when you look at the plain language, it looks to me like it's pretty clear that whatever the purpose was, it was 2 residents on any 5 acres.
2 residents on any 5 acres, which, as we have urged, most likely refers to platting and not to any sort of density restriction. But nevertheless, the purpose of the inquiry is to look at what was the initial purpose. If the purpose was to ensure that the property was developed appropriately and with proper platting, that's been met. Because now that's in the ETJ, platting requirements apply. I'd say that that's my time.
Any other questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Rubin will present argument for the respondents.
Thank you, and may it please the court. The court should affirm the judgment enforcing these deed restrictions that the association members relied upon to preserve the rural character of the area when they bought. I'm going to focus on 3 main reasons why the court should affirm. First off, the trial court and Court of Appeals correctly construed the deed restriction as a density limitation, which limited the number of residences that EIS could build on its 5-acre tract.
What is your response to his argument that this is simply a platting issue and that therefore, that's what we look at?
Yeah, it's twofold, Your Honor. One, that focusing on the language itself, and 2, looking at actually the path that you would take to get to this being a platting restriction. The EIS refers to Chapter 212 of the Local Government Code. That's not even expressly referenced in these deed restrictions. Let's assume that someone reading these things were to find their way to 212 of the Local Government Code and look at Section 004, which provides that tracts, if they're divided into parcels of greater than 5 acres, don't need to be platted. If you look up one subsection to 212-00384, it says that the city, and there's an equivalent provision in the county platting requirements, that the city and county can't even regulate the number of houses that can be built per acre in the ETJ. So you have to proceed through that labyrinth, and then they come back and say you need to look at a Supreme Court decision from 1998 that says that at that point, a county or city may be able to regulate density in the ETJ if it's not a true density restriction, but if it's a water control provision. So that's just not a reasonable reading of the statute. And, while my client's interpretation is not dispositive, both Mr. Hall and Mr. Smithy testified that they relied on these deed restrictions to control the density out there. And to have this turn into, having to navigate this labyrinth of case law and statutes to see this as a platting requirement, it's just not a reasonable interpretation.
Well, but is it reasonable to interpret it as a minimum lot size restriction?
It is reasonable to interpret it as a minimum density restriction.
Well, that's not really what's happening. Effectively, it's becoming a minimum lot size restriction, right? Because your position is if you have a 2-acre tract, you can't build anything on it.
It depends what else.
Is that correct?
It
Is that your
depends-
position?
It depends what else is in the area, and you need to look at it in the larger context, Your Honor. It's really important to step back and note that when these 2 parcels were sold off from the state to Mr. Lemon in 1998, subject to these deed restrictions, they were sold off in a 10-acre parcel and a 90-acre parcel. So we have tracts of larger than 5 acres to begin with. And then at that point, it's also important to look how the word tract is actually used in these deed restrictions, because paragraph 1 is not the only reference to tracts. If you look at paragraph 11, Your Honor, it refers to the tract. These restrictions bind any persons entitled to the tract. And then if we look at paragraph 1, where the main restriction, the restriction at issue in this case is, it refers to no more than 2 residences on any 5-acre tract.
But as you just pointed out, there wasn't any 5-acre tract at the time, and there was a 10-acre tract and a 90-acre tract.
There was-
So it must have contemplated that they might be subdivided at some point.
It does contemplate that they might be subdivided, but these deed restrictions can't be completely circumvented by subdivision. I think as EIS acknowledges in its brief, if it's tracts of 5 acres or larger, this applies as a density restriction. If it's let's take the example of the 10-acre tract being divided into 2 5-acre tracts, and then the 5-acre tract then being divided into 5 1-acre tracts. In that instance, Your Honor, they couldn't circumvent the deed restrictions by simply subdividing. There would still be a 5-acre tract there even after subdivision. You would combine the...
Wait, so I'm having trouble understanding why some later tracts are recognized as tracts and others aren't. Because you're using the word tract to say, well, this was sold in a 10-acre tract, but if it's later subdivided into 2 5-acre tracts, then one of those counts as a tract. But if you further subdivide it into 1-acre tracts, those don't count as a tract anymore?
I think they would, Your Honor, because you need to look at the term any tract. It's not a 5-acre
Right.
tract, it's any 5-acre tract. So if you have 5 1-acre tracts, there is still a 5-acre tract there for purposes of applying the deed restriction.
So say you divided the 90 acres into 91-acre tracts, and somebody wants to put a house on one of those tracts, and there's not a house anywhere within 5 acres around that in a circumference. Is it okay or not?
That would be okay because there wouldn't be more than 2 per 5-acre tract.
But that's not even a tract. I mean, nobody sold you that circumference around the house.
Well,
So how can you interpret that as a tract?
Because I think the word any, and tract, if you look at Black's Law Dictionary, is defined as any specified parcel of land. So there is a specified parcel there, Your Honor, by looking at, multiple subdivided tracts together. The other really important thing to keep in mind here is that in Tarr and in Tarr's progeny, they suggest that we should avoid interpretations of deed restrictions that would render that restriction a nullity. And here, this would allow this restriction to be basically rendered a nullity with some very basic real estate.
Not for tracts of 5 acres or more.
Well, even for tracts of 5 acres or more, it would have to apply to tracts larger than 5 acres and tracts smaller than 5 acres. And if you look at paragraphs...
I mean, isn't it commonly done that you have a minimum lot size restriction to avoid that entirely? I mean, why, it seems like that your interpretation would easily have been achieved if it said you can't subdivide into tracts smaller than 5 acres, right?
That would be an alternative way to state it, Your Honor.
But you're asking us to read this as if it said that.
And I think it does say that, Your Honor. It's an alternative way of saying it because it refers to any 5-acre tract. The other thing to note about these restrictions is that the drafters understood how to treat different tracts of different sizes differently. That's paragraph 4 and paragraph 8, the livestock restriction and the commercial sign restriction, where they apply to differently to tracts smaller than 16 acres and larger than 16 acres in a different way. You can do one commercial sign on a 16-plus acre tract, no commercial signs on a tract of less than 16 acres. So if this were to apply exclusively to 5-acre tracts, it would have almost no application at all and be rendered a nullity. I'd also like to mention on the waiver defense that the central principles of waiver still apply, and what Mr. Caulfield and EIS are referring to is a specific application of waiver in the context of a subdivision. So stepping back just a moment, my clients, the members of the association, per the language of these deed restrictions, only had the opportunity to enforce them on tracts that they personally adjoined. So if there was a property that violated similar deed restrictions half a mile down the road, Mr. Hall, Mr. Smithy, and the other people touching Salvador or EIS's property couldn't enforce it there. And the cases cited by the petitioner occur in a different context where there's a subdivision, and either under the express language of the subdivision restrictions or under this common law rule saying if there's a general scheme, anyone in the subdivision can enforce it, that allows a person at one corner of the subdivision to enforce the deed restrictions at the other corner of the subdivision without adjoining. Anyone living in that subdivision can enforce. Here, we're focused on prior principles of waiver that aren't even implicated in the subdivision, aren't in dispute in the subdivision context because the right to enforce is not in question because it applies to every owner.
When we're going back to the deed restrictions and what they mean, when we're interpreting restrictions like this, is the question, what was the intent of the drafters? Or is the question, does this put a buyer on notice of the restriction? And what do we do if the answers to those two questions are different?
I think the primary question, Your Honor, is what was the intent of the drafters? That's what this court's authority says. But I think, again, it has to be taken in the context in which the state and the buyers were drafting these deed restrictions, and that is to sell off, as Mr. Caulfield acknowledged, 12,000 plus acres of land, and to ensure consistency in development so it's not subdivision here, ranchette there. The drafters chose this construction as a density restriction.
Well, that's understandable from their perspective, and it's easy to imagine how. I mean, it's hard to imagine how somebody would have written this language and thought that it was accomplishing that. But when you ask, well, what else could it mean? You can sort of imagine that it was their intent to do what you're saying that it does. But then, from the perspective of somebody looking up the deed restrictions to know whether they want to buy this property, I mean, what it seems to suggest is that maybe that at some point there were a bunch of 5-acre tracts, or that was the original plan, and there used to be, there just aren't 5-acre tracts, and so the provision just seems to sort of be non-operative from the perspective of somebody who's reading this to understand what their rights are as a buyer. And so my question is just when the intent of the drafters seems to point one way, but the ability of the rest of the world to understand the restrictions when they buy the property sort of points in a different way, how do the courts sort through that?
I'm not aware of a case directly addressing that. The authority from this court says that you look at the drafters, intent of the drafters at the time the deed restrictions are put into place. I think there is something really important in the record to note. As Mr. Caulfield, mentioned, there's not a lot in the record about how these tracts were sold off, but we do have some evidence in the summary judgment stipulations. They're the tracts that EIS bought, 10 and 90. Then there are 3 other tracts that are referenced in the summary judgment stipulations. I think there's the Smithy and Mullengraf tracts who own those today. Those were each sold off in 10 acres. And then there's also a 59 or 60 acre tract, part of which today is owned by Mr. Hall. So all the evidence in the record suggests that these were all sold off in tracts larger than 5 acres,
Right,
suggesting it should have a
and
broader
just
application.
to go back to what Justice Busby's saying, you keep using the word tract to refer to like a legal segment of property that's been split off and treated differently from the surrounding property, which is not the sense in which you want the word tract to operate in the deed restriction. But is the sense in which we naturally use the word
The
tract.
sense in which we naturally use it, and also I think the word any does a lot of work here. The result could be different if it were referring in paragraph 1 to a tract or the tract, but it is any tract.
Well, any 5 acre.
But there never have been any 5 acre tracts.
There never have been any 5 acre tracts, which suggests it applies across the board as a density restriction to tracts smaller than 5 acres and tracts larger than
Or
5
perhaps
acres.
suggests that it contemplates a circumstance that just never came to pass.
And I don't think that's the case, Your Honor, because there's never anything suggesting that this would be, divided specifically into tracts of exactly 5 acres.
To take you back to the waiver arguments on changed circumstances, the trial court precluded evidence of changed circumstances and developments that had arisen before the purchase, before the buyer bought these tracts. And that seems to put owners of land affected by changed circumstances in different positions depending on when they bought the property. So a longtime owner could contest the development and contest the enforcement of the restrictions by pointing to all these changed circumstances, but a new owner in the exact same position, affected by the exact same changes in the nature of the surrounding property, could not. And that rule seems out of step with the rest of the country, with the restatement. Wouldn't it be a better rule that would apply to owners regardless of when they purchase the tract?
I would answer no, Your Honor, for a couple of reasons. One, the longtime owner and the recent purchaser are not in the same position. The longtime owner who's held for 20 or 30 years at one time had a ability to use the property productively that was diminished over time by the combination of the deed restrictions and the changes in the area, in contrast to a recent purchaser who buys with notice of the deed restrictions, knows what's going on, isn't in the same shoes.
Well, aren't they in the same shoes in the sense of, oh, there are these deed restrictions, but they haven't been enforced for the last 4 or 5 decades, because looking around the tract, they're all developed as in violation of these restrictions. So they certainly aren't enforceable.
And, Your Honor, that's the
Why
distinction.
wouldn't you take with notice of that?
Yeah, and that's the distinction between the waiver defense, which, as the San Antonio court noted in Traeger v. Lorenz, can apply to violations throughout the lifespan of the deed restrictions, versus the changed conditions defense, which applies for a new owner only to changes after they bought. And the new owner is not helpless in this situation. They can rely on waiver, they can negotiate their way out of these restrictions under the amendment paragraph. They can factor it into their purchase price when they're choosing to buy the property.
Right, but a jury, in deciding whether changed circumstances occurred, shouldn't a jury be allowed to think about everything that's happened in connection with adjoining property, not just what's happened in the last 2 or 3 years?
I don't think so, Your Honor, because the equitable doctrine is meant to help the party, a person that's been truly hurt by these changes. The longtime purchaser whose ability to use the property has diminished over time.
So if you were the tract owner in Mike Mulligan and the steam shovel, and skyscrapers had come up all around you, and you bought that tract thinking, well, I could put a skyscraper on this, because they're all around me, and I buy it, and then somebody says, well, those skyscrapers all pre-existed your purchase, so you, the last one that wants to build a skyscraper, are just out of luck, because everything around you is now a skyscraper, but you can't be a skyscraper.
And Mr. Milligan isn't out of luck there. Mr. Milligan can.
Mulligan, but yes.
Mulligan, I
Yeah,
apologize.
it's a children's book.
Can rely on waiver. He can negotiate under the amendment provision, or he can factor it into his price in deciding what to pay for the property. So Mr. Milligan or Mulligan is not helpless in this circumstance. It's just one of many ways that deed restrictions can be changed in their equitable doctrines. Going very briefly back to the waiver defense, they also refer to platting, and I think it's really important to understand platting in its context. Platting is not zoning. Zoning is a discretionary decision done by the P&Z and the governing body of the municipality, whereas here platting, as this court recognized in Schroeder v. Escalera Ranch, is a ministerial act. If the proposed plat meets the local regulations and state law, the P&Z has to approve the plat or whatever governing body is deciding the plat. So again, if my clients had objected to the plat, it would not make any difference. The local authorities would still have to approve that plat. And going back to waiver principles, if an act would be futile if they could object, but it can't be taken into account and couldn't make any difference in whether or not that plat would be approved or denied, it can't be an intentional relinquishment of a known right for waiver purposes. I think they're the Fowler case and the Underwood case, both out of the Waco court, which recognize you only have to do things that could actually make a difference in order to, either waive or not waive. If it's not going to matter, it doesn't count.
Can I just ask, you only have 30 seconds left, just, I want to make sure I understand your construction argument, because there was a conversation here that made me wonder if I did. So if I bought a 5-acre tract, exactly 5 acres from EIS, your position would be that I can build no more than 2 residences on that tract?
Correct.
And what if I bought a 3-acre tract?
Then you would have to look at what else is going on.
I only own those 3 acres.
Yeah.
Under a deed that has that language, can I build more than 1 residence on that 3-acre tract?
It depends on what else is built in the surrounding area based on the fact that these initially came out of a 10-acre and a 90-acre
Okay,
property.
so and that's where you get to if I bought a 1-acre tract, if each of us bought a 1-acre tract next to each other, 9 acres altogether, only 3 of us could build a house, a residence.
That's
That's your
correct.
construction?
Yes.
Okay.
That sounds great, though, doesn't it?
Let's do it.
Depends on if it goes in seniority.
Any other questions? Thank you, Mr. Rubin.
Thank you.
Now, do you agree with that much, that if I bought it, under your construction, if I bought a 5-acre tract from your client, do you agree that I can only build 2 residences on that 5 acres?
Yes, Your Honor.
And what if it was a 3-acre tract?
Then we start having problems. And I think the court has illustrated what those problems are, in particular with the notice question that was asked. So if I own a 5-acre tract and I build 2 houses on the southern end of that tract, and the person then buys a 3-acre tract that abuts that southern part of my property, and they want to build on their 3-acre tract, there's nothing that would give them notice that they can't build their house.
Your
And yet
argument would
his,
be, because it's a 3-acre tract and not a 5-acre tract, then the deed construction doesn't apply.
our argument would be that
Then
it does not That's
deed
correct.
restriction doesn't apply. That would be your argument.
Correct, Your Honor.
Which is, I mean, that's inconceivable as the actual intent, right? Because to say that 5 acre tract's gonna be subject to this rule, but 4.99 acre tracts and 5.01 acre
It's-
tracts are not going to be subject to this rule is, I mean, that's an absurd construction of.
And the only way it's not absurd is if you look at it as an intention for zoning and plating to occur at some point in the future for those smaller divisions that would happen after
But what about the
mergers.
bigger ones? What about the 5.1 acre tract? It's not a 5 acre tract.
Well, then you would not have the plating requirements apply. And again, plating applies when you try to start subdividing into smaller pieces.
But just to be clear though, is
Sure.
it your position that the deed restriction would not apply, would not limit me to 2 residences if I bought a 5.1 acre tract?
Not according to its plain language, which is what we should be applying here.
Not, you mean, yes, that is your position?
That is our position, Your
Okay,
Honor.
but if I bought a 5 acre tract,
bought
it
it-
would apply. 4.9 or 5.1, it would not apply.
Correct, Your Honor,
Okay.
because the language applies to any 5 acre
No, I
tract.
understand.
Any of that set.
I just want to make sure I was understanding both.
And that's
your
all we can draw
positions.
from that.
Yeah.
Now, as to waiver, there's just a few cases I'd like to draw the court's attention to that weren't in the briefing. The first is Stewart versus Welsh. That's at 178 Southwest 2nd, 506, a case from this court in 1944 that looked at waiver and noted that changes further away from a property could still raise a genuine issue of material fact as to waiver. And so that kind of rebuts the idea of this lot-by-lot analysis that's been raised. And then finally, going to the changed conditions defense. Other states have considered changed conditions. They've addressed this question. For instance, the state of California in Hurd versus Albert in 1931. It was faced with a question of, a court has decided a few years ago that there weren't sufficient changed conditions. The case has come back. Is it res judicata? No. This court quoted from that case in Marino versus State Farm for that proposition. But most importantly, it looked at the idea of if I buy with the express purpose and knowledge of the conditions and I want to change them, is it inequitable? And the court said, no. We should look at the conditions from the dawn of time because if it has become inequitable to apply them, then it is equally inequitable to bind someone to them. And second, that when a purchaser buys, they buy all rights, and those rights include a right to challenge that preexists.
Any other questions?
Was it your understanding that the position of the other side is also not exactly what the Court of Appeals said? So that, for example, if there were a 2.5 acre tract and somebody built 2 houses right across the fence line from you, I think their position is you wouldn't be able to build anything on your 2.5 acre tract.
That's my
Is that-
understanding of the opinion as written, yes, Your Honor.
Any other questions? Thank you, Mr. Caulfield. The case is submitted, and the court will take another brief recess.